of the large expanse, the latitude given to judges to bring contempt proceedings against persons who in their view, have scandalized the courts. That is why, as we speak, in the UK, where we inherited our common law contempt has been reduced into statute. And I think that in the development of our democracy, judges and the courts must open themselves to constructive criticism.
Right, so you heard Dr. Ayine in there, particularly speaking at that panel discussion which has led to this situation. And of course, you also heard Honorable Fuseni in there giving his remarks or thoughts about the letter referring Dr. Ayine to the GLC by the Chief Justice. Once again, you're welcome.
Thank you.
It's good to have you. So, coincidentally, you were on that panel discussion.
That's
so
right.
You heard it right as it came out of Dr. Ayine's mouth. And subsequently, you've had also cause to give your reaction to that. Now, let's understand exactly what about the statements made by Dr. Ayine is found to be offensive to the judiciary.
Thank you very much and good morning. Yes, as you rightly said, I was part of the panel that were chosen to review the Supreme Court petition, the presidential petition, together with, I think, 4 or so other persons, 2 from out of the country, I think Kenya and Uganda, if I'm right. Later, other people also joined, Sheshe Akutuampao joined, and a few others also. And we had a very healthy discussion, including, I think, Mami Mensa Bonsu so as well. And let's put it on record that I think we all spoke approximately 20 minutes or so in total. And I had to react almost contemporaneously when an aspect of what Dr. Ayine said, in my view, was quite offensive. None of us reacted to any other part of what he has said. So it is not as if everything he said was offensive to me or scandalous.
So what was that thing?
It was the aspect, and I don't want to quote, but I think it bordered on whether the judges that sat on the presidential election petition case had a mind of their own, and that they were not independent. It really hit me, and just before I had realized, I had told him, you are out of order, you are completely out of order. On the program, yes. Right. Contemporaneously, I said that. And Mami Mensa Bonsu also questioned him, and even the host asked him to give specific instances. So I asked, so first of all, it means somebody was controlling them. Who was that person? It means they are not independent of what they were doing, which means they were dependent on someone or some people. And it was important to point out these to substantiate your point.
Is that when he went into to talk about the fact that there were lack of reasons given for the refusal and dismissal of applications and all?
Yes, those things preceded this last statement.
Okay, so he laid a foundation.
Yes, he laid a foundation. Okay. I mean, there's no doubt about that. And so it is for those who appear to be agitated, is their right anyway. And it's as if judges now don't like to be criticized. That has not been the case at all. Because all of us critiqued the judgment. I mean, H. Prempe, you know him, Professor Asari was also on the program. If I got to a time, I think Professor Asari even disagreed with Dr. Ayine on some other matters about how, I mean, the conduct of the proceedings. But it was just that aspect, and he appeared to highlight it a bit more. Indeed, just before we ended, I told him that if he found my reaction also offensive, he should forgive me. But I think it was just contemporaneous, and I still stood by by it, and I still stand by it that perhaps he should have put it differently. But of course, somebody will say, "Who am I?" But the point really is that knowing who Dr. Ayine is, and when I was listing lawyers who have had influence on me in my book, I mentioned him, and so we have all looked up to him in terms of the practice. One of the finest you can get, one of the finest deputy attorney generals. I mean, he stands to give a speech, and you really feel that a lot of research has gone into it. But on this occasion, I think that he erred. And I believe that if he is given the opportunity again right now, he will never repeat those words.
I saw an article that was written, and you had made that statement that you feel.
I strongly believe that.
Subsequently, you haven't had any discussions with him?
No, not yet. I wanted the dust to settle a bit. But I strongly believe that he will never repeat those words. Right.
Now let's look at this. It looks like there's a lot of people who are of the opinion that perhaps this is an attempt to, as it were, quote unquote, gag people from, speaking out. Why do you think there's that level of sentiment, in that direction?
Well, people are truly free to express their view, but as I'm saying, throughout the program, which lasted in excess of 1 hour, none of what all of us said has become the subject of this invitation. Not even 90% of what Dr. Ayine said is the subject of this invitation. It is that particular aspect. That's why I say that perhaps, in all fairness, if he's given another opportunity, he will retract it. But, you see, as for criticism, judges themselves welcome it. And if you permit me, my favorite quote from Republic versus Mensa Bonsu, and I'll go a bit further just in a few minutes. And this is Justice Adade. I would wish to caution that we all, the lay public, the legal profession, and the judges themselves have a stake in upholding the integrity, authority, and respect of and for the judiciary. If this should collapse, one of the surest foundations of our democracy would have vanished. And we shall all be the poorer for it. And he goes on to say, of course, judges, like any other group of human beings, do make mistakes and should and indeed ought to be criticized. At times, some of us feel that our judgments are not being criticized enough, especially by the legal profession. I expect, however, that the language of criticism will be tempered and measured. It is not often remembered that judges, seen by many as very strong, are in fact the weakest members in the society. We receive blows. We cannot throw any. A factor to be taken into account when a member of the public is inclined to criticize us.
Right, it goes on and on and on and on, but essentially the point is made.
And this has always been true in 1995, 96 when it was said, and even more so today. Right. And I said that the moment a decision is given to your client and he instructs you to appeal, and you do appeal, or you go up for certiorari to quash the decision, you are criticizing the judgment. And so nobody, especially judges, have never been averse to criticism or criticism of their decisions.
Right. After a judgment is made, definitely that stays is there. But let's look at this. Is it to say, because reading from this and in your earlier submissions, the impression is that the judiciary has a certain place in society.
That's right.
And the more confidence we put in that institution, the better. But it can't also be the case that if indeed there are questions, real questions to be answered about its seeming non-independent status, that too, it doesn't mean that we cannot talk about that.
Yes, obviously you can. And But if in doing so you impugn their integrity, or you use language that may be tended to impugn their integrity, that, as has even been repeated here, is what may be offensive. But let's also put it in context. The invitation, I mean, I always say that if you are an active practitioner and you have not yet received an invitation to a disciplinary committee, you can expect one in your lifetime. I mean, and people go there. There had been earlier publication of 3 of our colleagues who had actually been invited based on some comments they also made on the presidential election petition. And they were either acquitted, well, let's say a petition was put in for them or a plea was put in for them, and I think they were cautioned and asked to go. So it's not as if it's a place where it's a Sahindrin where you go and you are deemed guilty before you even appear. So the language used in the notice is alleged to have made this statement. So, but I think, again, knowing who Dr. Ayine is, he may take steps that may in a way show that perhaps that statement shouldn't have been made. I mean, he did the same thing.
But perhaps he believes in that statement because he, like we've already, I mean, Jifa in that interview brought that up, that this was something he said when the petition was, being heard. Cited for contempt, ordered to purge, which he did. Then subsequently, he makes that statement. That's quite consistent, and that perhaps speaks to something that he's convinced about, don't you think so?
There's a point in that, but the fact that he also withdrew the earlier statement and apologized also means that perhaps he did not seriously believe in that viewpoint. Otherwise, he wouldn't have apologized and he would have suffered the penalty for it on his honor.
Right.
Yes, it has been repeated. Perhaps is almost to say to err is human. But I wait to see whether in this particular circumstance he may want to stand by it and defend it.
Will the context matter in that in the first instance the matter was sub judice, so perhaps there was a certain urge that, well, I should, we all know that when a matter is, being heard or still being adjudicated, you're careful, you don't say things that could prejudice the outcome or not. But post the hearing, some would say, well, this is perhaps an academic exercise, an intellectual exercise he's engaging in. He can speak freely, and if he's not allowed to, he's being summoned to the GLC, then that is a red flag being raised, and people henceforth are not even going to freely critique judgments or proceedings that are over and all of that.
Well, that's a point that people can make, but unfortunately, I disagree. My point is that, as I told you, I mean, we were on the program, spoke at length, critiqued the decision. A lot offered some recommendations as to what should be done. I mean, Professor H. Prempe went at length to list certain recommendations for future, if you like, guidance or let's see if the authorities will adopt it. So it is not about criticisms, as I'm saying, but a criticism that may be seen or deemed to impugn the integrity of the judiciary. That is the point that I believe this whole matter is about. And no one is passing judgment. That's why he's been invited for allegedly making that statement. But because of what my own immediate reaction, which I think I still stand by, that it was better those words, particular words, were not used. I'm not the one to suggest how he should choose his language, but I am saying that knowing my own Dr. Ayine, I've known him quite a bit. I mean, he can say in public the role some of us played in law when the other matter came up. And we stood by him, and it went past. So I think that he will not repeat that.
If given the opportunity.
He may have been in the heat of the moment. That may be one argument, but as you pointed out, or some have pointed out, Maybe it's twice too many. But the other opposite to is right. Perhaps in the heat of speaking, we all err sometimes. But I think that as he did for the first one, if it's something that is consistent with what I think about him, his nature, his demeanor, general disposition towards everyone, his respect for even younger ones. And I had cause to wonder why the younger or some of us coming up haven't really picked up some of his fine disposition. I mean, he's a fine man.
Right.
But on this occasion, I'm saying that he may agree with me that it wasn't appropriate.
Very well. Now let's look at the referral. Do you think this reaction is coming in because it was a referral by the CJ? Had it been any other person, do you think would have had this level of, it may be a bit speculative, but I think it's worth interrogating. And we'll go into the composition of the General Legal Council. Perhaps that is why people are raising these concerns. Do you think it would have been any different if it had come from any other person, maybe any other lawyer or somebody but the CJ?
But the often is it came from the office of the Chief Justice, is the Judicial Secretary's hand, which is
saying that the
which
Chief
appears
Justice has,
on it.
yes.
Yeah. So, and it's not unusual. I mean, people can testify to the fact that this is not the first time office of the Chief Justice has sold somebody to the General Legal Council. It's not the first time. I don't think it's even the second or the third time. It happens. I mean, the Chief Justice or the Office of the Chief Justice is the overall supervisor of this whole the judiciary and by extension the profession of which we are all proud members. So when anybody, including the Chief Justice, believes that something has been done or a conduct has been exhibited that may violate any of the code of ethics, the provisions of the code of ethics and the regulation, I think both he and any other person who has the authority to do so may be permitted to do so. Remember, there was one case against a High Court judge, which the former Chief Justice raised the issue for his removal. And he went up to the Supreme Court. The argument was that, it has to be a person who reports to the president or petitions the president, and then it is referred to the Chief Justice, and that it was wrong for it to emanate from the Chief Justice to the president and back. The Supreme Court said the Chief Justice is also a citizen of Ghana, who, if she also believes that any conduct of a judge may violate his oath or the clear code and the regulations and the law that bind them, then the Chief Justice, as anybody else also, could also petition the president.
Right. So, the Chief Justice is just as a citizen as all of us.
Yes, and I don't think the Chief Justice is a member of the disciplinary committee.
Yes, that's true, but he is the chairperson of the General Legal Council.
That's right.
Can people be convinced about the fact that, yes, he's not going to be a judge in his own course? Because that's what people are saying. You refer the matter to the disciplinary committee of a council that you chair, overall superintendent.
Well, that's what the law says.
How is Dr. Ayine going to find justice? Is what is the $1 million question.
Yes. It's a genuine point someone may raise. But then the law has been very consistent now. I mean, a reasonable man does not have a reasonable fear that even a prejudiced mind will give a decision against him. Whatever it is, that is what the law says. You have to appear before a council, a disciplinary committee of a council of which you are, which binds a profession that you are a member of. It doesn't disqualify the Chief Justice. Of course, you have to submit yourself to that body and put across all your viewpoints, defend yourself vigorously if you so wish. There have been instances where after the decisions, I think you mentioned my own good friend, Mr. Sosu.
Yes.
The High Court has even set aside the decision of the disciplinary committee. And so it is not as if even their decision is a final decision, judicially. It's not. So it is important that we express some apprehension, but at the same time, you are also fortified. And I say that, look, if ever God gave us a gift, then he gave us the gift of judges who are bold, fearless, independent. And in fact, when Mr. Sosu's decision was given by the High Court, a lot of people expressed a view that tended to confirm that our judges are very independent, because you may not have expected a High Court, and people were wondering what a High Court judge can do with a decision. Of course, the word "dare" may even be used. A decision of the disciplinary committee of a council. I mean, where Supreme Court judges are on it as well. Some even said that it may not have been proper that a High Court judge will set aside a decision of a disciplinary committee made up or chaired by a Supreme Court judge. Yeah. But as we know, the decision stands. I think it was not even, it has not been set aside. Sure. So let's continue to have confidence. Where the law has provided processes by which we must follow, we must do so. In our view, even if you fail, there are hierarchy of tribunals, including the courts, that you can at least ventilate your point and then get a decision that, at least if you doubted the justiciability or the justness of the first one, you may get what you want, even as some may think that the council, the disciplinary committee may be too strong. Our judges have shown that when it comes to justice, they just determine matters based on the law, the facts, the oath they have taken, their own conviction, and believe in God.
Right. I will want us to go back to something Dr. Ine said, in perhaps trying to justify his assertion that he doubted the independence, because like you said, he laid the foundation and there were a number of things he said. But before that, let's look at some statements made by H. Kwesi Prempeh. You said he was a participant on the show. I just want to know, I just want to know what his reaction was. You said contemporaneously you came out like that. He obviously has a contrary view. So definitely, I don't think he would necessarily have raised a point of order. But did he have anything to say when you came in to say that was something that was inappropriate? We have the audio of H. Kwesi, but we'll play it.
I don't remember that any of them reacted. It was rather Mami Mensabos, I'm sure that's her full name, who also raised an issue and said, Doctor, I think that you may have to substantiate this allegation.
Very well. Sorry to catch you, but I think we have on the screen the comments posted by H. Kwesi Prempeh on his Facebook page. He's asking the question, so now members of the Ghana Bar cannot offer a personal, unflattering opinion of the judiciary on an academic, a civil society, or other public discussion platform, even after a case has been decided, without risking being hauled before the disciplinary committee of the General Legal Counsel. Then he asked, really? So obviously he is, coming from the stock that says, well, this should not be encouraged.
Well, as I'm saying that everybody is entitled to their viewpoint, but then it should not also be portrayed that our judges or the authorities are averse to criticism. That has never been the case, and that is not the case in the instant matter we are discussing right now.
I'll read further what he posted, and then the various points he raised will be interrogated. It goes on to say that on the same platform where this lawyer expressed the opinion that has earned him an invitation to appear before the disciplinary committee of the legal professions regulator, other panelists, including other lawyers, strongly disagreed with him in his opinion of the judiciary regarding the case under discussion. Goes on to say, let me see if I can pick it up from here. In other words, okay, it goes on to say that, with some praising the court's handling of the matter. In other words, the platform on which the lawyer spoke was a veritable marketplace of ideas and opinion, with panelists debating each other in frank, open dialogue. And this, incidentally, was a webinar discussion organized by CDD Ghana in collaboration with the KNUST Law Faculty as part of a new judicial review series. He explains that's a partnership between CDD and 2 law faculties in Ghana that aims to review and examine the decisions of the courts for their impact on democracy and good governance. This particular panel, which examined the recent Ghana election petition through a comparative lens, featured 2 foreign participants from Kenya and Zimbabwe, 4 Ghanaian lawyers, and me, that's him, Ishkwesi Prempe, that an opinion expressed at such a forum to contestation from other participants would cause anyone to lodge a formal complaint with the Disciplinary Committee of the General Legal Council is unprecedented, bizarre, and ill-advised. Not only is this bound to have a chilling effect on the free speech rights of lawyers, it will also impact negatively on both academic freedom and the freedom and ability of civil society to promote judicial accountability, including through projects like the Judicial Review Series. Then he goes on to conclude, I find no justification whatsoever for the Disciplinary Committee of the Ghana General Legal Council to be brought into this matter or to investigate Dr. Dominic Akuritinga Ayine for the opinion he expressed on the panel. It cannot be okay for a lawyer to praise a court for its handling of a matter, but an act of professional conduct or contempt of court for another lawyer to express a contrary view on the same court about the same matter. Quite some strong opinions there.
Well, I mean, as I said, I mean, he's entitled to his view, but let the impression not be created, and we cannot repeat it more than we have done, that anyone, the authorities or all of us, are against a critique or an act of criticism of the decisions of the court. I mean, as we say, all the time that we file an appeal, sometimes you even say aggrieved by the decision of the court. Some judges prefer dissatisfied, but we still use the word aggrieved. Yes. Sometimes as it pleases the court. So you are clearly showing right there your dissatisfaction with the decision of the court. And that, in my view, should not be stretched to the point where we are saying that because of this, our judges or the authorities are against criticism. You see, no one relishes in another, or he himself being invited to the committee for investigation. No, I mean, I can't imagine that even the very people who have invited Dr. Ayine glorify that act or are happy to invite lawyers to, but I mean, invitations are extended all the time. And I wish that...
And due process will have to be...
Yes, but I wish that, of course, one wish that it had not come to this in terms of what has engendered it, but it has happened. He's been given previous opportunity. I mean, we know what went on in the 2012 presidential elections and what Sir John, in his soul rest in perfect peace, went through, and his friends, Ken Crunchy and so on. This time, it didn't happen like that, even though some believe that they were similar in nature. The authorities now are very friendly. I mean, you see how opportunities were given us to comment right after the court, and you were not expected to just praise them. There was some room for some criticism of how people understood it, both in the English and the Twi language, for example, until some persons, in the view of the authorities, crossed some red line. They were invited. Even at that stage, a plea, we understand, was put in for them, and they were asked to go. So perhaps they also believe that they have a law to enforce. And if they don't enforce it or are not seen to be enforcing the law, then they would have also violated the law themselves.
Right. But and like you said, it doesn't end at that.
No.
There's a right of appeal.
Yes,
and
that is if a decision is given against you, there's a right to go to the High Court. But I'm saying that I strongly believe that what happened to the other colleagues where they were discharged, even at the early stage, I think that if Dr. Ayine believes that this was not a statement that is consistent with his nature and that he shouldn't have made it, I believe that he understands that the proper steps to take in order that the situation may also end at the earliest possible time. Because when he's a member of parliament, he doesn't have time. Well, he has to travel far and near, even to his constituencies. And you can imagine that on a Thursday, you may have to be in parliament with this almost so-called hang parliament, and you may have to appear before the council. I think that there's more opportunity for him to ensure that perhaps what he did earlier on, that endeared himself to the authorities, may be the same approach he may adopt if he does not stand by what he said. But of course, I also like people to stand by what they say and face the consequences for it, so that at least, the world will also know that you're a man of your words.
Exactly.
Unless he believes, as I do, that he erred.
In the heat of the moment, like you said.
Yes.
But you see, it's interesting that, perhaps not even interesting, that it's quite significant or worthy of note that the letter referring the matter made reference to that earlier incident. And so it's like, yes, we already have you on account as having done this, and then this comes in. So that first time incident is likely to play a major role in whatever decision, and this isn't to prejudice anything,
yes.
But indeed that is a fact. But Senior, let's look at this as well. The letter says that His Lordship the Chief Justice therefore finds his alleged disparaging comments totally unacceptable, and would like you, that is the disciplinary committee, to investigate this matter further. So perhaps there's an opportunity for Dr. Ayine, if he has any evidence of that compromised independence, then he has that opportunity to present it.
Exactly. I mean, it's your right to be heard and be offered adequate opportunity and facility to be heard will apply as it applies to all other instances. So the people there, mostly lawyers, Supreme Court judge or judges, and so they understand these things. I don't think that anybody will be out there with a prejudiced mind. It's a referral, it means there's a complainant, and there's a person against whom a complaint is made. The reason why I'm saying that it is perhaps better for appropriate steps to be taken so that possibly what happened to our other colleagues will happen is that, as long as these matters are on your neck, your name and your complaints are online, perhaps you may be lucky some international organization or even an internal organization or domestic organization wants a lawyer. People shudder. These days they go there, they shudder to take a lawyer who is facing disciplinary committee charges. So it's very important. And for a member of parliament, I cannot say it more than I have.
Sure.
It is very important that appropriate steps are taken, perhaps to benefit from the magnanimity that was shown our other colleagues. And if possible, let people see that there's some there may not be the need to let me put it. Let me leave it there. But then,
right.
Whatever happened to our colleagues who were discharged, I think he may contact them. Maybe perhaps if he doesn't stand by it, then it may end and or be truncated as early as possible for him to also benefit from that show of mercy and magnanimity.
Sure. Let me announce quickly, though, that we were expected to be joined by the Honourable Member of Parliament for Medina constituency, the Honourable Francis Javier Sosu, who himself was at some point at the General Legal Council and had, successfully was able to get the decision of the General Legal Council overturned by the High Court. So indeed, we would have loved to have his perspective on this issue. We're trying to reach him, but we're not getting through. We'll do our best to continue. But in the meantime, we're having a great discussion here with lawyer Yao Opong. Now, Doc, let's look at this, lawyer. Like I said, the reasons that were raised by Dr. Ayine in coming to that opinion that he put out there. But before we go into the reasons, we need to take a break. We'll take a break quickly, and when we come back, we will delve into the other angles of this matter. See you shortly. Welcome back. You're still watching and listening to the Key Points. We're live on TV3, also live on 3FM 92.7, online at 3news.com, and on Facebook at TV3 Ghana. So we're currently having a conversation here with lawyer Yao Opong, particularly looking at the referral of Dr. Dominic Ayine by the Chief Justice to the Disciplinary Committee of the General Legal Council over alleged comments made questioning the independence of the judiciary. And this has to do with the just ended election petition of 2021 filed by the flag bearer of the NDC, John Dramani Mahama. In fact, the referral letter describes the comments made by Dr. Ayine as disparaging, and that is to be investigated by the disciplinary committee. So, Ms. Opong, let's look at this. I talked about the reasons that he had given. Talking about the fact that there was a lack of, or the court failed to give reasons for the dismissal and refusal of applications. And does that in any way justify, the conclusion he came to?
I think that point can be made, that in your view, you expected judges to give reasons. But in this case, in all instances, reasons were given. In fact, all the applications that were brought, it is sometimes forgotten that our own application for the case to end at the earliest possible time, because we thought that there was no reasonable course of action, was not granted. And that was a major
It was postponed to be determined together with the entire.
And when it was determined together with the judgment, it was rejected flatly.
Obviously, I saw that coming, because if it was going to be upheld, it would have been done earlier rather than.
And for us, we thought that was more fundamental than any other application, because we strongly believed that there was no reasonable course of action. It was rejected. So it is not as if every application of theirs was rejected, and as if ours, that is speaking for the second respondent, was granted. That was not the case. Our application, which was, we had one major fundamental application, was rejected. And in the course of the hearing, objections were raised by us, which were not upheld. They are also a form of questions that had been put, even though there was no formal application. A lot of times, if I got to a time, our lead counsel also thought that he was not being extended the same kind of magnanimity that was extended lead counsel for the petitioner. I mean, that was a genuine concern that some of us also felt. But that is the nature of it. So no impression should be created to make it seem as if one person was done in and the other side benefited unduly from the decisions that the court gave throughout the proceedings. No, It is not the case at all. And I'm saying that in all cases, reasons were given. These decisions, and we all have them. Fortunately, a lot of them were online. You can go back and check. There were very extensive discussions in them, and sometimes you wonder how in a day or two they were able to nitpick various points that were made, got the authorities for them, and ruled on these points that were raised in the course of the proceedings. So even if a judge gives a decision without reasoning, it can never be a foundation for any claim that then that judge has no mind of his own or is not independent. It can never be, in my view. And that is why I'm saying that Dr. Ini himself needs to have a reflection over this, and I believe he would have.
Very well. Now let's look at this as well. The rules for the conduct of a presidential election petition were revised.
That's right.
To avoid what we saw in the previous election petition of, was it 2013? Where it took forever, 8 months. I mean, the discussions over that prolonged hearing, I mean, we all know about that, which obviously led to the revisions. And so clearly for this one, we set out knowing that we were time bound.
That's right.
Do you think that may have affected how people perceived the proceedings? Because there's been instances where people have had cause to complain, or people have complained about the CMC that was held, that the rules allowed for a certain time frame, but it was done shorter than the time frame allowed. It looked as if, yes, we were trying to meet that, was it the 42 days within which to complete the process from the time the petition is filed and all of that. Do you think, in as much as that revision was made to serve a certain purpose, perhaps it brought about some sense of, let's hurry up to do something, so people may come then to say, we were rushed through the process and all of that. Is there any weight to that kind of argument?
Well, I, by my nature, I don't usually say that anybody is wrong on this point. On the law, I'm saying that I disagree completely. I mean, it doesn't matter the length of time given you. I mean, currently, there are some judges that hold a view that because of CI 87 and how now you filed your witness statement, attach all your exhibit and so on, the idea that cross-examination is the sky is the limit, no more holds, and they will pin you down. I did said one day you have to finish, 30 minutes, 1 hour, you have to finish, and you have to finish, because the judge who is making the determination has had the benefit of both the pleadings with witness statements, and possibly would have made up his mind, and just waiting to see some clarifications that will be made this way or that way. So in this particular circumstance, and I'm saying that in spite of the quote-unquote limited time, and again, it is not exactly, I disagree if somebody says that anyone was rushed through. The point is that within that period, opportunities were offered. I mean, you have no idea when you have prepared for the next day, and then midnight an application is filed and you need to prepare for that one and the previous one, and as the ruling is being given, there's a review that is filed. You can't go home, you have to go and sit on it. So all of us would have wished that there was more sufficient time to deal with it. But that is what the law now says, and I think it did not hinder a fair treatment or fair opportunity that was given, or that the case itself demanded. It was fairly contested. The whole world saw it. In the court, sometimes you go there 9 o'clock and leave there after 5 p.m. The strain on us was telling, and on the judges themselves. So it's not as if that they would have wished, it's not as if they didn't want perhaps more time, but the law had bound us. And for the case management issue, when you put the days together, it was more than that, because remember, amendments were made on the other side, from the other side, responses were made by us. And when you put all those days together, the time for CMC was exceeded. You understand? And the bottom line really is that this matter was fought fairly and squarely. Both lawyers, all lawyers in it did exceptionally well. The judges were on top of their case on all the applications that were brought. And because we know that the Supreme Court is not only a policy court, but the Supreme Court, quote and unquote, makes laws for the rest of us, and especially the courts below. And so it is very important that the time given them would have been longer, but within the short period, inordinately short period, prescribed by law, they were able to discharge their duties, for me, perfectly. And so whatever it is, your disagreement or dissatisfaction, in my view, cannot lead you to say that because of that, they don't have a mind of their own, or right, they are not independent.
Now, another sticking point in this election petition obviously had to do with the EC's, the EC chairperson not mounting the box to, give evidence, and that has been described as the Supreme Court shielding the commission from, rendering an account, as it were, to the people. And indeed, Dr. Ayine talks about the accountability aspects of it. He mentions it here in laying the foundation for his eventual opinion, which he stated, questioning the independence of the judiciary, and that they didn't have a mind of their own. Let's talk about that a bit.
Well, I mean, I still believe that anybody can make their points known on these matters. But in terms of this whole proceedings, it will be just unfair to impugn the integrity of the judges. Because when matters came up, opportunities were given. I mean, sometimes 1 hour to a lawyer to argue his case out cannot be said to be inordinately insufficient. And when all these opportunities have been given and the case has been fought from the beginning to the end, we saw how they extended some unfamiliar magnanimity to the parties and their lawyers. I mean, sometimes you ask yourself, even a district court, no, I don't mean to demean them, but a district court judge would not entertain lawyers in their court the way the Supreme Court in the election petition case, because of the special nature of it, extended this unprecedented, to use the word, magnanimity and entertainment of matters that in ordinary cases you will not get that. And so we need to look at all that in totality and come to the conclusion that whatever happened during that period, they were within the law, the facts were supported. The final judgment, I mean, is one of the best judgments that I have read. And the authorities have clearly been on point. And when people express their view on these matters, that is fine. Coming to the accountability of the Electoral Commission, the fact that the Electoral Commission was sued itself is a call to accountability. It is basic, even with all due respect, in the Chief's Palace. It is said that you cannot compel a person to drink the water when, after you had even compelled that person, and this time using person for a horse, as we put it, to the river. it is even unfair to compel a person to give evidence against himself, to implicate himself, and so on. You have brought him to court, and it is for you to establish your case first on the pleadings, that's the facts that you present, and two, on the evidence, before the other person is called to answer. I mean, this is very basic. And if he says that, and it is done before the Chief's Palace tribunals.
But you see, you stated, I mean, in all the discourse over election petitions, at the heart of it is the recognition that the presidential election petitions take a certain space.
That's right.
So the argument that we should treat election petitions or presidential election petitions as quote-unquote special, some would say perhaps there's some truth in that. And so if we're treating it special, then you're talking about the unfamiliar magnanimity that is extended to. Of course, I mean, watching the proceeding, you're like, whoa, if only you would have days like this in the Supreme Court. Because you don't get it like that.
Yeah.
So then there's that, quote-unquote admission that, yes, then there's some special place we give that. So then perhaps you could also then
Yes, but you should remember
do some things about.
You should remember also that special, quote unquote, special nature of the case must be within the law itself, and the established principles and practice. Can you really, in treating a matter before you as a judge as special, violate the common principle that you cannot compel a person to give evidence against himself? For example, you can compel him to appear before you, but it is for that person to decide whether or not you give evidence. And when the person has filed his evidence, and that evidence is yet to be received or adopted by the court, is it really fair to violate the law by compelling that person to give evidence? The law says that even after the person has filed his witness statement, that person in law can elect not to ask the court to adopt that evidence. And when that is done, I think that you cannot say that because of the special nature of this case, and in spite of the fact that the law is clear and unambiguous, we will in a way violate it in order that the special nature of the case can be realized.
Very well.
Knowing that judges, like the rest of us, are also bound by the law.
Very well.
And when you are giving such concession to other person, you must think about the person against whom that concession may be applied.
Very well.
And it's important that the right of, for example, it wasn't only the EC. President Kufuor also said he won't give evidence. So would he have been right to compel the EC in the circumstance to give evidence, but the second respondent, you'll be okay with it if the second respondent was not compelled to give evidence?
Very well. Laura, let me cut in there and cross over to Zoom, where we've been joined by Mr. Sami Jemfi, the National Communications Officer of the National Democratic Congress, NDC. Good morning. Mr. Jemfi, can you hear me?
Yes, I can hear you.
Great. Thanks for joining us. Hope you're doing well.
By God's grace, I'm good.
Good.
Yes, look for me. It's been a while.
So,
I will, senior.
right. So we're looking at this issue, which is of great importance to many. Obviously, coming from the legal fraternity, this is of importance to you, in as much as, yes, Dr. Ayine is also coming from the NDC. Now, let's look at what we have before us, the referral by the CJ of Dr. Dominic Ayine to the Disciplinary Committee of the General Legal Counsel. Some have said that in view of what transpired during the election petition hearing, where Dr. Ayine was actually cited for contempt for similar comments made. Perhaps he should have known better to avoid making similar comments even after the petition had been heard. What do you say to that?
Good morning to your cherished viewers. Let me make the point that even though I'm a lawyer, I'm speaking on this case as the National Communications Officer for the NDC. Because as a lawyer, I work in the chambers of Dr. Ayine. And so ethically, that wouldn't have allowed me to comment on this matter. But because of my role as the National Communications Officer of the largest opposition party, the NDC, I am bound to comment on this matter and let the public know what the position of the party is on this issue. My sister, the point is the freedom of expression is guaranteed under the 1992 Constitution. That's freedom of expression of all citizens. In a democracy, all institutions are subject to that freedom of expression. They are subject to scrutiny and criticism by the people. And the judiciary is no exception. We as lawyers know that judicial decisions are not sacrosanct and can be critiqued constructively. If you look at the comments of Dr. Ayine, which is an issue here, or which has necessitated his referral to the disciplinary committee of the General Legal Council. As a political party, we don't see anything wrong with that comment. There is nothing in that comment which, in our view, scandalizes the judiciary or the Supreme Court of Ghana. There is nothing, absolutely nothing, in that alleged comment that breaches any of the rules stipulated in LI 613 or the latest LI in the Legal Profession Rules or the Legal Profession Act. Nothing in that statement constitutes a misconduct by a lawyer, either under the Legal Profession Act or in LI 613 or the new amendments. And the letter referring the matter to the disciplinary committee of the General Legal Council does not make any allusion to any such rule that has been violated or breached by the alleged comment of Dr. Ayine. Again, if you look at the letter from the chairman of the disciplinary committee of the General Legal Council to Dr. Ayine, asking him to respond to the petition from the judicial secretary, there is no reference to any such provision in any, of the rules I have mentioned, whether it's the Legal Profession Act or it is LI 613 and so on and so forth. So what misconduct has Dr. Ayine committed to deserve or to warrant this decision by the Chief Justice and the General Legal Council? As for the General Legal Council, you can't even blame them because a petition or a complaint has been referred to them and they are supposed to investigate. But one would have thought that at least their letter to Dr. Ayine, which I have been privileged to have cited, would have made reference to what specifically they are investigating him for. But there is no such reference. And that is because of the fact that Dr. Ayine has not breached any of the legal profession rules and etiquettes for lawyers, or has not misconducted himself in any way. My sister, what is Dr. Ayine alleged to have said? The man says that, for me, that's speaking for himself, after the Supreme Court had delivered its judgment on the 2020 election petition, the Supreme Court breached certain known procedures of law. And that for him, that dampened his hopes about the independence of the judiciary. I mean, is that not an opinion, Dr. Ayine, is entitled to. He's entitled to have an opinion.
Mr. Jeff, let me come in here quickly. Fair point. He may have made an opinion, but for this particular incident, if you like, or in respect of this particular issue, Dr. Ayine had or has a history of a similar comment. And so when we are looking at this particular incident, which is the panel discussion where he made the comment, we're also looking at the history where he made a similar comment.
No,
but the letter does make reference to that. We can't take away.
No.
We can't run away from that. Just a minute. Let me land.
That is even unheard of.
Let me finish the question. Let me finish the question. I'm not done. So after he made that comment during the hearing of the petition, he actually apologized for making that statement and said he was out of step. He shouldn't have made that statement. And so for him to come back a few months later to make that statement again, then it raises issues about that. You once apologized for making that statement, but you've gone back to make that statement.
That is false. That is not what happened, or that is not what has happened. The statement Dr. Ayine made that led to that contempt, charge being brought against him by the Supreme Court, for which he duly apologized for, and for which he was discharged by the Supreme Court, is materially different from the comments he made on that CDG platform after the judgment was delivered.
How so?
And I don't want to go into the details because
but how different
I was
is it?
very active in the election petition. No, if I can explain that to you.
Sure.
In that statement, he made comments about certain things that had been done by the Supreme Court, showing that they had a predetermined mind, or they had a predetermined position against the petitioner and all that. I'm not sure that if you read the attached publication to the letter from the chairman of the disciplinary committee to Dr. Ayine, you will get a sense that he is alleged to have made a comment that the Supreme Court had a predetermined mind about the case.
But he raised issues about the independence.
No, but I'm saying that
right?
No, but in the first comment he didn't talk about his hopes about the independence of the judiciary. So I'm saying that we are dealing with two different and distinct situations here, and the two cannot be equated. The first one, another difference is that the first one was a contempt proceeding. Okay, this one is a disciplinary proceeding which has been brought against him by the Chief Justice
for making comments that he had made earlier, similar comments.
But so you know that contempt and disciplinary proceedings, contempt proceedings against a lawyer or a Ghanaian, a citizen, a person, is not the same as disciplinary proceedings against a lawyer.
No, I get that, because but please let's not make things up. You were looking at the comments made first. You're looking at the comments made.
Give me 1 minute. You will get the thrust of my answer. I'm saying that there are two answers I have to that question. In the first place, in my opinion, the two statements you are talking about are not the same and cannot be equated. The second thing I'm saying, the point I'm making, is that a contempt proceeding against a person is different, which is the quasi-criminal matter, is different, materially different from a disciplinary proceeding against a lawyer for misconduct. And as lawyers, we understand the difference. Number three, that contempt issue, the comment for which he was cited for contempt, that he duly purged himself off and he was discharged by the Supreme Court, has been tried and determined. It's been tried and determined by the apex court of the land. And so how that matter, which has already been settled, be disposed of, can form the basis of...
No, but I don't think it's forming the basis. Mr. Sami Jemfi, I don't think in my submissions I'm saying that forms the basis. Not at all. The fact is clear, or it is a fact, that Dr. Ayine, during the election petition, made statements for which he was cited for contempt and purged himself off.
Yes.
That is,
it
yes.
is true.
But it's not a basis for him making the statement. I cannot say that for him. That is a basis. But I'm just saying that
So why did the judicial secretary, why did the judicial secretary make reference to a comment which has already been dealt with by the Supreme Court and been settled in this petition? What has that comment got to do with the comments Dr. Ayine made after the Supreme Court delivered this judgment? Which comment is materially distinguishable from the comments he is alleged to have made in the course of that the hearing of that petition. So please, I am saying that if as a lawyer on an academic platform, okay, where academic freedoms are guaranteed, I'm called upon to do a critique of a judgment of a court, and I say that in my opinion, these known rules of procedure were ignored by the court in the way it dealt with certain interlocutory applications of the petitioner. And so for me, my hopes about the independence of the judiciary has been dampened. And you say that that constitutes misconduct. I mean, what rule does that preach in the Legal Profession Act or in LI 613 or the new amendments, which borders on, I mean, rules and etiquettes for the legal profession? I have not seen any, and I will be happy for anybody to show me which, I mean, provision has been breached by Dr. Ayine, or how has he misconducted himself in this matter, to the extent that neither the letter from the Judicial Secretary nor the one from the chairman of the disciplinary committee makes reference to any such provision or any such misconduct. The NDC thinks that this may well be another attempt to suppress dissent and victimize critical voices. And we are determined to fiercely resist that. We need to protect our democracy as citizens of this country. We are enjoined to do so by the Constitution. We need to prevent state institutions, from arrogating to themselves the powers to summon and punish those who criticize them, because the criticism may not be pleasant. Once they have not scandalized the court, once they have not impugned the integrity or the sanctity of the court, I think that people should be allowed to express themselves without any intimidation or harassment whatsoever. I heard Lawyer Point, if I can make this point, talk about the fact that in his opinion, the Supreme Court did nothing untoward, which is his opinion and which I respect. But in my opinion, known provisions of our laws were sidestepped by the Supreme Court in the hearing of this 2020 election petition. Take, for example, the issue of who an adverse witness is. When we all know in the Supreme Court, when the Supreme Court adopted the Black's Law Dictionary of who an adverse witness is, which runs contrary to what our own Interpretation Act says about an adverse witness. When the Supreme Court said, a person cannot be an adverse witness until and unless that person has mounted the witness box, was that not a clear error in law? And yet, when the Supreme Court was given an opportunity to correct this error in a review application, they refused to do so. So that per incurium decision, in my opinion, that bad decision still stands. If Dr. Ayine is raising some of these issues of procedure, which in his view went contrary to the laws of this country, and he says that my hopes about the independence of the judiciary has been dampened. I mean, what is wrong with that?
Thanks, Mr.
Is the judiciary going to dictate to him what his hopes about the judiciary should be?
Thank you. Your point.
Are we all bound to go with the views of the judiciary about what their independence are? It is for the citizens of this country to assess the judiciary. That is his opinion. That is his assessment. And as a political party, we think that is in order. We stand with him, and we will stand with him and fight this case to the very end. Because today it can be Dr. Ayine, and tomorrow it can be Lawyer Pong. And so we must all work hard. We must all boldly
Lastly,
come together and ensure that we protect.
Lastly, Dr. Ayine, and I quickly go to Mr. Opon. He apologized once for making disparaging comments about the judiciary, and standing by him, what happens if he should, repeat that apology? Would you still stand by that?
I don't think. I mean, I've had conversations with him that I am not allowed to put out. But from where I stand, I don't think that he will be apologizing to anybody on this matter because he has done no wrong.
Very well. Thank you for that.
Even if he decides to apologize, it doesn't stop anyone from expressing an opinion that supports the position he took, or that says that we don't think that what he has done warrants his referral to the disciplinary committee of the General Legal Council. That is also our opinion.
Sure,
we are entitled to that.
That's fine. Thank you. Mr. Pong, quickly, if you have a few reactions to that.
That's vintage Sami Gyamfi, isn't it? Well, I mean, I don't want to comment on his opinion in this matter because, to be honest with you, nothing he said, in my view, is offensive.
But raising issues about the breach of known procedures and principles, referring to the use of adverse witness.
If it was a court of appeal, that can be a ground for appeal at the Supreme Court, what he said. I mean, when you say that, put the judgment and the facts side by side, the court may have, that's normal general omnibus appeal. Explanation is that the court ignored or failed to consider certain facts, and for that matter, give judgment in favor of another party. That is not offensive. And I don't think that the matter really is about criticism. Because I will repeat that nothing he has said, in my view, would have led me to contemporaneously say that he's out of order.
Very well.
In actual fact, I mean, he has expressed his view, and even if a court ignores settled practice and the law and the principles, it cannot lead me to make the point that it's evidence of a court having no mind of its own or not being independent. So I think in that aspect. But
that's not exactly what Dr. Ayine said. Dr. Ayine didn't say that the fact that the courts ignored known or settled principles of law meant that the court didn't have a mind of its own. He said that dampened his hopes about the independence of the court. That is him speaking
how else can you interpret that?
Mr. Gyamfi,
how else can you interpret that? Having laid that foundation and coming to that conclusion.
I don't want to disrupt.
No, it's fine. I'm saying that I have nothing wrong with what you have said. In fact, I'm not even in the position to judge. That is vintage you. It is fine. But I am saying that it is okay for all of us to criticize decisions of the court. And the court encourage that, as you have already said. It is for Dr. Ayine to decide whether, as he did in the previous situation, whether the two are the same and therefore he thinks he has erred again, or for him to stand by what he has said and defend to the end. And that has happened in previous situations. We still go back to Honorable Sosu's situation. There have been others whose own had been varied on appeal. So that invitation, and as I said, I don't wish that to happen to Sami, but being an active lawyer one day or the other, an invitation will be extended and you will go there, all the opportunities that avail anybody against whom a charge has been made.
I will come to you to be my lawyer when it happens.
I will stand by you, but I will express my opinion first as to whether or not.
Unfortunately, this is where we need to bring this part of the show to a close. Thank you, Mr. Sami Gyamfi, for joining us. We appreciate your
contribution. Thanks for having me.
Right, sure. So that's Mr. Sami Gyamfi, the National Communications Officer of the NDC. He is a lawyer as well. And in the studio, we had Mr. Yao Pong, also a private legal practitioner and a member of the NPP legal team in the election petition. Was it the NPP legal team or the Nana Addo
a member of Nana Addo
so Nana Addo the legal team, sorry about that. Anyways, we'll take a break. When we come back, we turn our attention to issues about June 4th. You do know that yesterday was the 42nd anniversary of the June 4th uprising. We shall be discussing that. See you shortly. Thank you very much. Welcome back. You're still watching and listening to the Key Points. We're live on TV3, also live on 3FM 92.7 and online at 3news.com. Also on our Facebook page, TV3 Ghana. So we're moving on next to look at the commemoration of the June 4th uprising. Yesterday was the 42nd anniversary of the June 4th uprising, and the peculiar thing about yesterday's celebration or commemoration is that it was done without the involvement of the late former President Jerry John Rawlings of blessed memory. We'll be taking a story about the commemoration yesterday, where we had the late President's daughter, Dr. Zanato, speaking at the occasion. We'll take a listen to some aspects of the things she said and return to our panelists. Let me quickly introduce our panelists. From my extreme left, we have with us Major Retired Boachi Jan. You all know him very much a forerunner when it comes to the June 4th uprising. In fact, he led the June 4th uprising. You're welcome, sir. It's good to have you.
Thank you.
And also Joseph Ni Laye Afote Agbo, former MP for Bon Kataman. So it's also good to have you, Honorable, and you're welcome to the show. So we'll take a listen to the story on the commemoration of June 4th yesterday, and where we had specifically Dr. Zanato making some remarks we'd like to listen to. So let's take a listen to that and come to our panelists in studio.
For the first time, the NDC celebrated the day without the founder Jerry John Rawlings following his demise last year. Chairman of the NDC, Samuel Ofosu-Ampofo, recalled some of the admonishment of the founder during the celebration of the day before his passing.
Because of COVID, last year we celebrated the June 4th at his residence, if my memory serves me right, and we did a virtual celebration. And he stressed on the need for us to keep the principles that necessitated the June 4th uprising. The house cleaning exercise, the quest for probity, accountability, the quest for social justice, the quest to ensure that issues about corruption and nepotism are dealt with head on.
Daughter of late President Jerry John Rawlings, Dr. Zanato Ajiman Rawlings, described the absence of his father as an indication that principles always stand the test of time.
I think it's a reminder that no one lives forever, but principles do. And the hope is that as we celebrate the 42nd anniversary of the June 4th uprising, it's to take cognizance of the situation, the circumstances that led to that, and to look in the mirror as a society in terms of government, in terms of individuals, members of the society, and re-examine what it is that we are doing, the situation as it is now. How does it resemble what was happening then? And advise ourselves accordingly.
She stressed current leaders must learn from the happenings that led to the June 4th uprising.
This day is meant to be a reminder of the circumstances that led to the uprising, and to remember to espouse those values and principles that help to maintain what we have. This is the longest lasting republic that we've had since independence, and it didn't happen by accident. We shouldn't take it for granted. We must value and respect the different rights and responsibilities that come with maintaining what we have going forward.
Samuel Ofosu-Ampofo said the call for government to fix the country reflects the reality on the ground. He added the difficulties citizens are currently going through could not be different from what led to the uprising in 1979.
If you look at our society today and you see the crippling of the factors that led to the uprising, then there is every indication for us to rise up and ask the government to sit up and fix the country, as well as try and ensure that good governance, social justice, accountability, transparency and probity becomes part and parcel of our governance architecture. Today, as we speak to you now, even free speech is being criminalized.
The June 4th revolution in 1979 rose out of a combination of corruption, bad governance, frustration among the general public, lack of discipline and discontent within the Ghanaian army at the time.
Right, so that was a report looking at the commemoration of the 42nd anniversary of the June 4th Uprising, which happened yesterday. A number of speakers in there, the chairman of the National Democratic Congress and the daughter of the late President, Dr. Senator, in there. Let me start with you, Major. I know there's a lot to talk about, but unfortunately we don't have that much time. And we've had, this discussion about the June 4th uprising, May 15, 1979, and how it ties in with the June 4th, 1979 and all that. I've heard you in an interview say that May 15th, which is what the failed coup attempt by Jerry John Rawlings, which led to his detention and the subsequent release on the June 4th and all. You have indicated in an interview I listened to that May 15th came as a surprise because there was a certain bigger plan, which is the Free Africa movement.
That's right.
But that came as a surprise. But then when it happened, you took advantage and did what you had to do in respect of the 4th of June 1979 incident, because obviously you had to cover your backs, as it were. Let us understand the connection between the May 15th incident and then the June 4th incident. And if the statements you heard in the videos that we played from yesterday still resonate with you.
Yes. First of all, let me congratulate you for getting the terminology right. I normally squirmed when people talk about celebration of June 4th.
Right.
Because it isn't right to look at it that way. It was an act of war. People die on both sides of the equation, and you don't celebrate an act of war. It's commemoration, and I'm glad that you got it right. One of the few public figures who tend to get, even our own senator got it wrong. It's not a celebration, it's a commemoration.
Right.
I mean, forever the Queen and the royal household in Britain would solemnly take a wreath to the cenotaph and remember those people who laid their lives down for the First and Second World Wars and walk away quietly. That is what I crave could happen in the Ghana now. You see, but you are taking the lead. I think the campaign to commemorate it rather than celebrate it will take real roots if we look at it for what the essence of it. The roots of the so-called, well, not so-called, but reality of democracy now can be traced to June 4th. Because we probed, and arrived at conclusions and exerted the kind of punishment that you would think twice before you plunge the country into unconstitutional rule. So we should take it seriously. And my hope one day is that it will be a national event rather than a party event, because we acted for the whole nation. Democracy is not just for one party, it's for everybody. And that's why I feel elated that you got it right.
Right. Now, you're saying you're hoping that it becomes some form of national event.
That's right.
Because you think it was done in the interest of the entire nation.
That's right.
But what would you say to people who raise the issue about what happened subsequently, i.e. 31st of December 1981, by the person who subsequently became the face of June 4th?
Yeah.
Because if indeed June 4th was to end coups, then you had the person who became the face of June 4th subsequently.
Right.
He himself going to overthrow another constitutionally elected.
What that position...
So how then does it become something that, we would want to celebrate, like you're saying, as a nation, given what happened subsequently?
Because you see, what you don't say is that he himself had to be driven out of that position of 31st December illegality by handing over himself to a democratic arrangement. That actually confirms the durability of June 4th as a principle, because at the end of the day, even if somebody were to come tomorrow to take over from the current regime, we would crave for the day to go back to democratic politics. So why do we have to throw the baby and the water out of the basket? So we need to begin to set up that the time has come for us to elevate June 4th to a level of national commemoration, like the Queen and the Prime Minister of Britain, for instance. I'm referring to it because I lived there for 20 years. I know what they do. They will troop quietly to the senator, lay wreath in the memory of the soldiers who laid their life down so that the freedom of the world today can be traced to that. And I would like to look at June 4th, people Ghanaians to look at, especially the leadership, that it is the only legacy that is non-partisan in the context that we did not occupy a political space. We were not left-wing or right-wing or center or liberal. We just wanted the institution of democracy to take roots. And that's the difference. And if we want to protect that the nourishment of that root there, then we must go back to the roots itself and hold it up so that, as a friend of mine was saying, the children will be asking questions and they will have the answers. But if we just allow it to become a partisan thing, that a few people will pick it up and that, then we have lost the essence of it. And that's not good for
very well. Honorable.
I think I want to add a little to what the old man said.
Right.
We shouldn't only look at Rawlings coming back in 81 after June 4. We should look at what happened and what were the issues. What pushed him to come back in 81 after
So you're saying that 81 was justified?
Yes, after 2 years of handing over. It must be a lesson to us. Those of us who have been very close to the revolution and have been very close to the former president, we have learned a lot, and we have a lot of things with us as to how we should be doing our things. That is why when you take over a regime, or when you get the mandate of the people, you don't have to look at yourself and look at how you are going to do things in your interest.
But shouldn't that be determined by the people who put you there, so that you don't come back to overthrow a constitutionally elected government, which you set out to end by the June 4th uprising? The coups to end all coups.
Took advantage of the feeling of the people, being maybe a very sensitive, emotional person who had enough time to interact with people on the street and find out what was happening, getting to know of their feeling and the situation on the ground. He took advantage of it. And at the time he was walking and entering into Burma camp, he didn't plan with anybody. There were only 2 in number. And they entered into Burma camp without giving any soldier man any information or prior information as to his intention and what they wanted to do. But his appearance within the barracks at 5 p.m. and Reki, when they saw him, he told them of his intention of coming in. And they embraced it, all of them.
But that's just the militaries, not the entire citizenry.
I'm talking about, after getting to know of the feeling of the civilians, getting enough time to interact with them at various locations. Because within a period of 2 years, he wasn't sitting at one place. He was moving out and visiting communities and interacting with the youth and everybody. He had the time to do it. So he got to know of their feeling. And being an emotional, sensitive person and intelligent, he took advantage of it. And no one, he didn't get any much challenge of his action. And he went through. That is why we must learn as a country. Like Irauma was saying, the ideals of June 4 must be embraced by every Ghanaian.
But how do you say that and yet justify 31st January?
What I'm saying is that I'm not saying what Jerry did was legal. I'm saying that he took advantage of the feeling of the people to do what he did.
But he's still justifying it.
Maybe I didn't use the correct word.
But I mean, no matter how you put it, you're still justifying it.
You see, you may think of the period being given for people to come out and say, this is what we want. What if things are happening and the people are impatient and they cannot wait because people are dying, people are suffering, because it was the same people who said 4 years for a decision to be taken. And at the point, because of maybe the actions and inactions of some personalities, they think if there's a way out, they will not wait for the 4 years.
But surely it couldn't have been.
And you are talking about human institution. Human institution. Human institution. We must learn. We must learn as a nation. And we shouldn't just use, it's the same people.
What exactly are you saying we should learn? What should we learn?
We should know that when we come out, just like we want to believe in 4-year mandate, waiting for the legal issues to be done as to processes of elections and whoever emerges and all that. We should also learn of standing by the procedures as to how things should be done. But when laws are being bent, when procedures and guidelines and things are being turned around, the people will look at it and take advantage that if you have set the pace, if you have taken the lead in not going by the law, but doing something against the law, then we will also go against the law.
Really?
It will help all of us. So what I'm saying is that we all have a lesson to take.
Very well.
And we must be very careful.
Major, you'd like to make a comment because I see you.
Yes, I take a fundamental disagreement from his position.
Right.
In the sense that
if you
even
please
in
speak
our
up a bit for me.
traditional societies have a saying, "Oman yekina sinienswa." Because if you make a mistake of asking people to put the country on your head, they will gladly do so. But when the things start going wrong, you look left and right, and they're all gone. And you sag on that. And that's why even our traditional societies were democratic in that sense. They believe in change as essence of life, essence of political life, essence of whatever. Therefore, the mechanism that is available for us to mobilize and organize that is something that we must respect and cherish.
Right. Now, let's interrogate it further before we come to look at the modern day issues here. And this to you, Major.
Yes.
One of the members of the AFRC,
right.
is it, I think, Kwabena Bachamfo, yes, has, I mean, like, he's been quite categorical in his reactions or statements about the incidents back then, and raising issues about the executions of some of the 8.
Yes, right.
In his narration, he suggests that so the 8 were executed on the basis that they had done some wrong, which had been, they had been subjected to trials by the courts.
Yeah, People's Court.
Exactly, the People's Court, and then found guilty and then executed and all of that. Right. But he goes on to say that there were some, for instance, he mentions Utuka,
yes,
for instance, who was not necessarily linked to the coups of 1966 and 72, but was found to have been executed. So definitely going contrary to what the FRC had decided, i.e. that we're going after people who had overthrown constitutionally elected governments. He's been quite categorical in respect of this. What is your response to that?
I would say that he's got it all wrong in the context that, you see, even in the common criminal law, if a thief steals your book and you encourage the thief to give the book to you, you could be nailed for handling a stolen good. You understand? So we shouldn't make a mistake and think that somebody had to be necessarily involved in the actual coup making. What we did was assemble all those who have been involved in the execution and the management of the consequences of the coup, which was amounted to an illegal occupation of our country. So you couldn't be selective. law is not selective. Unless, if you have to make it selective, then you throw it away. We didn't do anything wrong there, because we needed to set an example that, like in the civil life, if you handle a stolen good, you didn't steal the goods in the first place, but you could be nailed for managing a stolen
complicity
good.
by reason of maybe standing aloof or...
Exactly, and encouraging it, so-called. So I think it's a very dangerous position to take, particularly by a man in uniform. You know.
And he was part of the revolution?
He wasn't part of it. He was...
Banchafo wasn't part of it?
No. We brought him in later.
Yes, but he became a member of the FRC.
Wait. So he could not have actually understood the reasons for some of the decisions we took. Because he was brought in after the event. You see? So let's make that absolutely clear. He's an individual, he can express his view, but it cannot be made to cover us, because he was not part of that decision-making process.
He says he came in on the 16th.
Yes.
After quite a number of things have been done. But Honorable, you keep on smiling when the decision come up. What's making you smile?
I have a lot more.
Sure, share that.
Because I was not part of them, but I had a privilege to be with the old man himself. And apart from the old man.
But he himself wasn't part of the 4th June uprising,
because
he was in detention. And yes.
I have some info from the old man, and I had some from those who even planned how to get him out of the jail, and how they are entering into the GBC office and all that. I was bringing the people to tell him what exactly they planned when he was not around, when he was in confinement. You know? So the ideals of June 4, their motive, the plan of June 4, I'm saying must be embraced, just like the old man said. I had a privilege to interact with the U.S. ambassador, and he asked me of some of my woes and problems I've gone through for being a minister. And I told him of the mentality of Ghanaians. Because somebody forged my signature to sell my property. And I couldn't take any action against him. Because if I should do, I will have the whole country accusing me of using my position as a minister to deal with somebody. But they wouldn't find out what happened. So I would advise the U.S. ambassador, and those of them, they have a major stake when it comes to taking Ghana to a level. We must have our teaming, or direct our teaming students from the military, and from the USS, to do that service with the military. Those are the institutions that we can boast on, with loyalty and being genuine and all that.
Some would also say that we've had our, hardships by reason of
for some of us,
that institution as well, because our political history has been riddled with several coups.
The evil of everything is money. And if you wouldn't see money as everything, and that can be taken out of your body and your thinking as a Ghanaian, when you are doing things, you first look at the issue, the country, development, the comfort of the people, and money will be the last thing. Because we learned this from childhood. So it has been with us.
Very well.
When adults being changed to a different level or into a different situation, it becomes a problem than when you are dealing with people at that younger age.
Sure.
So the students, our teaching students, are in the future going to take up positions in this country. But there are so many of them who are very brilliant, but they need to stand by the ideals of June 4, so that they won't only look at money, but development of our country and the comfort of our people must be their priority.
Very well. Major.
Yes.
Events that unfolded subsequently to present day Ghana, you look at these things and then you look back to the day 4th June 1979. Do you ask yourself questions? I know you've said that it should be perhaps commemorated as a national event.
That's right, not celebrated.
Yes. Do you look back and ask questions? Could it have been done differently? Could we have achieved the purpose that we set out to achieve in a different way?
My
you still
answer,
think that?
My answer is very simple.
If you could please speak up a bit.
Well, my answer here is very simple. We took a cue from the existing criminal code of 1960 and the subsequent constitutions that had been codified by it in it. And it says simply this, that if you took over, you remove an elected government anywhere without respecting the rules of engagement that existed, to do that, you have committed a high treasonable offense, and that if you were to be prosecuted and successfully, then you should suffer death by hanging, that kind of stuff. So that's why I looked at that, a few colleagues of mine, not me alone, and we generated the issue of principle for probity and accountability. That what is missing under military unconstitutional rule is that you don't have the opportunity to change things if they find out to be wrong, because change is an essence of life. Therefore, if I still believe that democratic arrangement is the best mechanism for giving out opportunity to examine and change things if necessary when they go wrong. Soldiers don't act that way. Our culture is not that way. You just act on orders. And it's a celebrated saying, principle of not subordinate officers not taking responsibility for the actions of orders issued by a superior order room, they call it. So if we don't have a mechanism to judge ongoing events and make the corrections, then we are in trouble. And it doesn't matter what the quality of the democratic mistakes of a democratic regime. If we don't have the means to get correction while they are serving, at least when they finish serving, we should have the mechanism to hold them to account. So the idea of saying that XY government is creating trouble for us, the soldiers must come in and do all that, that's not the issue. The issue is that do we have the opportunity to change what we don't like now? All right.
Which is what Honorable in his earlier submission was talking about, the 4 years and the time and everything.
Before the old man continues, let me say something.
Quickly, and then, yes.
For us to do all the things that he's talking about, some of the things we learned out of the June 4 is the moment you are appointed into whatever position, be it a president, MP, minister, or whoever, you don't zero on relations. You don't zero on friends. You must see every Ghanaian as your own.
And is that what Liman did, or his government did? There's no proof to that effect.
No proof to that effect.
So then,
I can talk much about, I think, the period that we've had within the fourth.
Because we're looking at a situation where the uprising comes in, the AFRC takes charge for about 3 months, hands over after the election to Liman, and then boom, how many years later? Less than 3 years.
2 years.
Exactly, you come back.
2 years.
So when you're talking about all these things, you don't focus on friends and all of that, then it would seem as though you're suggesting that was what happened to necessitate the comeback. Then that isn't even appropriate, assuming that even happened. It wouldn't have been justified.
I don't even want to dive into that area, because there's a lot that I'm aware of and I know that I can't discuss over here.
Well, let's take a break.
I'm talking about how we should do our things.
Very well. We'll take a break. When we come back, we will try to conclude on the historical aspects of it and then zone in now on contemporary matters and see how June 4th, moving forward, to be commemorated in the absence of Jerry John Rawlings of blessed memory and other matters relating to the NDC post the death of Jerry John Rawlings. This is the Key Points. Stay with us. We'll be right back. Welcome back. This is still the Keypoints live on TV3 and live on 3FM 92.7 as well on the internet. We're at 3news.com and on Facebook also at TV3 Ghana. We're looking at the commemoration of the 42nd anniversary of the June 4th uprising, which occurred yesterday. And the peculiar issue there had to do with the fact that it didn't have former President Jerry John Rawlings of blessed memory in attendance. We're looking at matters, historical accounts of it, and then we'll be soon zoning into the issues of contemporary times. Major, you were making a statement.
See, for instance, people would always confuse the position of Rawlings on the issue by forgetting that on 15th May, when he made the first move, it was against an existing unacceptable military regime. So that if he had to come a second time, when the situation was different, then we had to sit with that. That's why. That's why I'm of the opinion that whereas I can accept 15th May, I could accept and move to implement it, I cannot ever accept 31st December.
Right.
Can be no justification for it because it closes the workshop. And the fact that he even had to return to constitutional rule after that, I mean, certainly it's a proof. His own condemnation of his own action of 31st December. So we shouldn't confuse, as I said earlier, power with the opportunity to defend principles that would live long after we are gone.
Right. And like Zenato said there, Dr. Zenato, he said clearly the commemoration of the event yesterday without Jerry John Rawlings of blessed memory is testament to the fact that people don't live forever, but principles do.
But what she and others didn't talk about was that Rawlings was a very complex situation.
A very complex.
Complex in the sense that 31st December has also had to be accounted for in his lifestyle. It's not just the June 4th. June 4th, as a matter of fact, if he hadn't come, he would have been prosecuted and appropriate action have been taken against him. He probably wouldn't be alive, to do all these things. So we've got to confuse power. We've stop confusing power with the opportunity to use power to change permanent situation, principles. You don't throw the water and the baby out basket with the baby, that kind of thing we say. So there can be no way anybody can justify 31st December as against it. June 4th is different from 31st December. In our case, we rose up to
do a house cleaning.
That's right, house cleaning and probity and accountability, which I fashion, that kind of thing. Because there was no opportunity to do it under a military regime where you are supposed to do things in order, you act on order, because you know why? In the army, or in the military practice as a profession, subordinates are not meant to take responsibility for orders, implementing orders given by superiors, standing order rule. If you did it, then you are making things difficult. That's why I'm always take refuge in the democratic opportunity to change things in society, because the principles of good living, principles of making things good for us will always remain. But the way of doing it will be different, because different people will look at it differently, unless you are bound by a set of rules. I mean, if, for instance, you are attached to a political belief system, like say NDC, my party is, as a social democrat, you don't get angry because you have got a bad social democrat leading you. You change him and make sure that you replace him and make sure that society moves along your belief system. You see, this is the confusion that we are all caught in, that we need to do something about. Power is not necessarily the space, a place in the space of political spectrum where you want to position yourself to implement your power. If you're a conservative, the way you want to look at society would be necessarily different from the way a liberal in the lower minority and middle minority will look at it. And unless we in Ghana, in Africa as a whole, make a distinction and a commitment that you cannot occupy the whole political space. That's why you have a party. You are a part of a whole. But you have to understand which part do you stand on the political space. This issue has never been clarified, and that's why you can allow, we can confuse 15th May with June 4th, and June 4th, 31st December. They are all different things. And the complex, the fact that Rawlings did it does not stop us from being critical and say that it doesn't matter how bad the current regime is. If we don't have the means of disciplining him, then, like in 1983 in Britain, you heard about the men in grey suits. Margaret Thatcher was an elected prime minister, but she was not allowed to be voted out of office. That was a coup, if you like, but it was not also done by soldiers. Men in grey suits within the Conservative Party. Where are the men in grey suits in Ghana, where we can rely on, to take the action that needed to be taken, cleaning their own party before we are, as a whole, given opportunity to endorse somebody else or bring them back in.
Right. Now, you raised an issue about, I'll come to you, Honorable, very soon. I just want us to wrap up on the historical issues here. You raised an issue about principles.
Yes.
And I think when this discussion about June 4th and other coups come up, there's a talk about how people who purport to value certain principles, for which reason they take certain actions, they themselves are found to have gone contrary to the so-called principles that they hold dear. And here I'm looking at the fact of the sanctions or the consequences of taking certain actions. And we go talk about the indemnity clauses in constitutions, which is brought in to protect persons who perpetrate certain actions. But forgetting that when they came in, they perpetrated those actions against people, but didn't give those people the opportunity to be clothed, if you like, in indemnity clauses.
See, that's so much criticism of specific acts than the principle itself. You see, democracy as a means of changing government inevitably when things go wrong. It must not be confused with the ability to change things when you are in charge or after you are charged. If I have no provision to hold somebody to account when he is not in office, then the problem is so much with accepting a situation which should not be acceptable. Do we have the mechanism to make our life better? And if we can't, identify those who are made it impossible for us to make our life better and hold them to account when they are not in power.
But how do you hold them to account when you have indemnity clauses protecting them?
That's what I'm saying. If you have a democracy, it's nothing sacrosanct about indemnity clause. That's why I'm saying that if the Constitution has encouraged certain things to be said in, the sovereign parliament can override it and decide to, push it aside. Because I'm not worried to be examined by my conduct, So maybe in the heat of the aftermath of the revolution, people will be worried about so many things and they may misconstrue certain things. That's but time heals. And we need to have time to heal, but only if there are mechanisms to control the system.
Right.
As I get worried when people, like my friend, would encourage an undemocratic takeover of a country. Who decides who's going wrong at that time?
First, talking about time heals and time healing, Honorable, do you think time has healed? I mean, this issue of June 4th obviously is a sensitive part of our political history. It raises a whole lot of sensitive issues. Do you think time has brought about some healing? And perhaps we can look at the national reconciliation process. Do you think it brought some closure to this?
Yes. I'm saying this because that was how God made the world. If things happen to you within a period, maybe you lose your wife, or maybe you go through a situation through the hands of somebody, after a period, you may forget and forgive. And look at the time from June 4 all the way to today. I think there's no
I think
way
it's that simple. When
yes.
people are commemorating the day, keep on commemorating the day.
Oh, as for the commemoration, just like the old man said, looking at the ideals and the beliefs, it should not be commemorated by just a particular political party. We should all embrace it. For some time, when I was with the old man himself, some of our friends on the other political divide were seeing him as somebody who should not be even attended to, or no one should even get closer to him. I went closer to the man when he was even in uniform. He was practicing democracy in a way, though it was a military regime, because he dealt with people after doing maybe the wrong thing. His own nephew, when he took somebody's life, he didn't say he's my nephew, so he should go free. He was dealt with. So I think looking at maybe situations and whatever happened with time, and because of the time involved, we can't say we should just revisit those days and whatever happened during the time of June 4. I'm not rubber stamping on maybe 31st December and whatever happened. I'm not approving of it. But I always say that we should all take a cue and learn something out of it. That is why when you take over, when you are given a position through the mandate of the people, you must hold it well and make sure that you embrace everybody and see everybody as a brother and a sister.
Yeah.
That's the only way that you can take action when action needs to be taken. That is how you can rebuke somebody when the person does the wrong thing. And that is the only way that everybody will have justice. If not that, you will end up looking at relations and faces of people and then do things according to maybe how you want things to be done. But out of wisdom, deal with whoever makes a mistake, be it a family or
regardless of who you're dealing with.
Whoever, yeah.
Very well. Major, do you think time has healed? Do you think there's still some unfinished business?
Time must heal. No, that I see it must heal, because I always look at a situation where I give an example of bad popes without all the sensitivity of our Catholic believers. A criticism of bad pope cannot confuse the Catholic Church as a belief. The problem in our part of the world is that we have not made a distinction between the principle and the personalities being called upon even to manage the democratic arrangement. Until we develop to that point, even democracy will be just a paperwork. Constitutions will be paperwork. And we have to be very careful not to confuse, as I said, a bad pope, the conduct of a bad pope, as a criticism necessary of a Catholic Church, as a belief system. We must move towards a situation where our political parties, and they are called parties, you are part of it, you are not the whole of it. That's why in this current constitution it is enacted that nobody has the right to turn this country into a one-party state. I find a lot of problem with that because if some of us manage to organize ourselves and say, we believe in living under a one-party state, who is there to say you can't do that? So that the constitution as it is now has actually denied certain options in future. But that's not correct. That can't be correct.
But we've decided that as a people.
No, that's what I'm saying. But if tomorrow, as a people, we also decide that we want one-party state.
Sure. So far as so far as the people decide and it's the law, then
that's what I'm saying. Then
until
we change it. We can change it. But you can't say you can't change it. You see, because the people will always be there.
Which is why the Constitution will provide the means of changing
what
that?
I'm saying
if it's an entrenched provision, then we do a referendum, yes.
The people will always be there.
Sure.
Their interests will be constant. So if tomorrow the people were to come to say that we don't want it, but we want another arrangement to regulate our life, who is there to decide that for me today? That you can't have a one-party state. It's wrong. That's part of the problem I have with the current constitution. Nobody has the right to deny anybody the government he wants to live under.
But that's what the constitution is saying, and that is the constitution of the people.
But I think, so if the majority of the people, that's right, if one majority of the people were to decide tomorrow that we want a one-party state,
and so far as we change the constitution in accordance with law, then that would be cool. Otherwise, then it would be unconstitutional. Yeah.
So that putting it on the paper was wrong in the first place.
Really?
Because you cannot dictate for all time, for all people.
But who's dictating? It's the people.
That's what I'm asking the question. If tomorrow people want to go to the streets and say, look, we don't want this one multi-party state here. We want one-party state. Now, what would be the legal status of that? When the Constitution now says you can't do that.
So what they would be looking for would be unconstitutional in the circumstances.
Who decides that?
The Constitution.
Which Constitution? Whose Constitution?
Anyway, the people's Constitution.
That's right, and the people are saying we want to go one-party state. In other words, the danger is that we should not put ourselves in a position where we take decision for all time, for all people. We have an arrangement, yes, within which you can go and change things when they do go wrong. But you shouldn't make a mistake of institutionalizing certain principles as valid for all time, for all.
Very well. We need to take a break at this point. When we come back, we look at the implications of June 4th, the probity, accountability, integrity principles, and whether or not it still resonates with the country as we find ourselves in, and particularly the values as they relate to the NDC. We do know in the years before the death of the founder of the NDC, he had some strong positions about the party in respect of these core values. So we'll be interrogating that in the last part of our discussion here. So let's take a break. We'll be right back. Welcome back, and you're still watching and listening to the Keypoints live on TV, also live on TFM 92.7. We're just about to be wrapping up on this on the show this morning, and we'll be now focusing on the core values of the June 4th uprising, which have come to be known as probity, accountability, integrity, and all of that, and how it resonates with the NDC now. I mean, the founder, Jerry John Rawlings of blessed memory, in his latter years, had strong views about the NDC and had issues with how the party was quote unquote being run. Honorable, you do know about those sentiments the founder shared. Do you think that the NDC is, as it were, moving away of those values, even though we keep hearing the members of the party talk about it? We heard the chairperson in the video played earlier talk about probity, accountability, integrity, and all of that. But do you think there's some form of departure from those values?
I think we can't be perfect, or we can't maybe do exactly we are not doing exactly what the old man expects or expected the party members to be doing. But sometimes people also take advantage to go and then tell the old man of some of the things happening that wasn't true. And if I get the privilege, most of the times, to talk to the old man, I try to let him know of some of the things. That this statement that you made, I think you shouldn't have said it, or you shouldn't have come out to say some of the things that you said. Because looking at what we have done as a party and a government in terms of development and running the country, I think we've done our best.
So I think that some of those comments were made based on wrong information he was given?
Some are wrong informations being given to him. And we are the same people who should be telling him off some of the lapses and some of the wrong things and the false informations being given to him. So I did not hesitate in telling him of some of the things. There was a time we were to lay a wreath at the Rosary Square here. He got to the grounds before myself when I was even on my way coming. They had to call me to say that the old man is refusing coming down from the car because I was not on the ground. So I had to even speed up to come and join him. Before even letting him come out of the car, I had to engage him to at least let him know of some of the things that maybe he should be touching on, and not those that he shouldn't be saying at the program. And he listened to me.
He did.
He did.
Okay.
He respected me so much. So for that one, he wouldn't take away from me because after all,
no boom speech.
No. He didn't do it on that day.
Okay.
Because
Very well.
I don't have. He knew I didn't have any personal interest in maybe protecting somebody or promoting somebody's interest. So
very well. That's fine. Major, you will have the last word here, and in fact, I should have called you by your right title, Osahini.
That's right.
Osahini Bwahijan, and you have a book.
Man.
Oh yes,
Thank
in
you.
the works,
Thank you,
right?
thank you,
About to
thank
be
you.
published. It's titled Beyond Fear and Power.
Yes.
That's it. Talk briefly. What is this book about? Briefly, I think we've projected it on the screen now. Beyond Fear and Power, Osahini Bwahijan.
It's essentially a biography of me.
It's a biography of you.
That's right.
Sure.
I have a story to tell. In fact, I'll be 79 on the 24th September. Coming 24th September.
Happy birthday,
That's a
son.
stretch of so I've decided to recall, where necessary, or get reported the essence of my experiences of my 79 years. That's why it's a biography. The trouble I have with autobiography is that people you open yourself to all kinds of criticisms. You don't expect him to say all these bad things about himself. But if you commission somebody like this young man who is writing my book, he is my worst critic.
Sure.
You know, he won't put anything in that he himself does not accept.
Sure.
You see, so I've decided that to avoid the kind of controversy that has always shrouded discussion of June 4th, I needed to assemble certain incontrovertible facts in the recorded version that can be passed on to other generations. That's why I've written the book Beyond
Fear and Power. Right.
Hopefully, it will help assist our democratic development of this.
Set the record straight, as it were. Very well. Is it yet to be launched?
Yes, not later than 24th September.
Okay, so around your birthday.
That's
very
right.
well. So that's it. So
And
viewers
the
and
Third
listeners,
Republic too.
watch out for the book soon to be published or launched by Osahini Bwahijan, titled Beyond Fear and Power. It says Pioneer Journey from the Village to the City and Back. It's quite a nice title, but this is where we wrap up on the show this morning. It's been a great time here. Thank you so much, Osahini Major Bwahijan, leader of the June 4th Uprising of 1979, and a member of the AFRC, played critical roles in the AFRC in that 3 months that they had. And also we've had with us Joseph Nilaye Afuti Agbo, former MP, Pom Katamanso, 4 years.
In the region of Katamanso, 4 terms.
4 terms, sorry.
4 terms.
4 terms,
Yes.
16 years in
very
Pom
young.
Katamanso. Next time we'll talk about how that whole thing happened. But yes, it's been nice having you. Thank you so much. And to our viewers and listeners, we do appreciate your custom staying with us all the time. And we will be back here same time next week. Until then, stay safe and stay positive. And remember, COVID-19 is real, so keep adhering to the protocols. We'll see you next week. Have a good weekend. Bye-bye.